we don't need to hear from the appellants on round one. We would like to hear from Mr. Hickman, if he wishes and is in a position to do so, on ground 4, on which Mr. Beale made some headway with us. Does that take you by surprise, Mr. Hickman?
Well, my lord, it does, but that's not a problem. I think I'd be very, very short. We're very, very short in our written
Yes.
case. I mean, obviously, costs is quintessentially a matter for the trial court. They saw the way not only the trial was conducted, but the litigation as a whole. They saw the amount of disclosure, for example, that was required by my clients to be provided. They commented in their judgment that the way the case had been litigated was much more akin to a commercial court trial than a judicial review in terms of the document request, the document disclosure that was provided, and so forth. And they also mentioned that the claim was effectively pleaded against my client. So the way it was stood up, in particular by Scottish Power, was that it was a judicial review of the process that had been conducted by my clients. Now that point was effectively abandoned at the hearing, but effectively my clients were squarely in the crosshairs, and they might as well have been named as co-defendants. So that, I think, is one of the, or a number of the considerations that the court will have had well in mind when making its decision on cost. And in addition to that, of course, this is not a claim, if we look at the, as it were, the other side of the coin, this is not a claim brought by a single claimant. This is a claim brought by 3 very well-resourced parties who are sharing the costs. This is not a case where one claimant has to pay 2 or 3 sets of costs. And we made the point before the court below that if the claim had been successful, we fully anticipated that the cost would have been sought by all 3 of the claimant parties. My lord.
Where do you think the analogy with the position of the developer in a planning appeal breaks down?
Well, I mean, the first point to make is that's only a starting point in judicial review. A starting point in a judicial review is that an interested party won't have to either pay costs or be liable for costs. Either pay costs or recover their costs. And that's partly because you don't want to make a claimant responsible for 2 sets of costs. Not a factor here. But it's also partly because someone like the developer, of course they're interested, but they don't really have anything substantively to contribute. They didn't make the decision. They can make sort of supporting submissions, but it's not their conduct that's an issue. That was absolutely not the case here. I mean, you've seen the central point that was made in these proceedings, and that was relevant to pretty much every single pleaded ground, was that the process conducted by my clients was unfair, and that had it been conducted fairly, the claimants would have bid for Bulb. And as I say, for that reason, we are not in the same position as a developer of a judicial review. It's not a sound analogy. And the court saw very clearly how the case was progressed, the role that my clients played in the case, and in my submission, the decision that they made on cost was well within their discretion, having a very clear and close understanding of the facts and the procedure. And I'll make one final point. There was also a directions hearing, and I can't remember, I think it might have been before Christmas, in which certainly Lord Justice Singh presided, and I think Mr. Justice Foxton may have been there as well. And at that hearing, there were all sorts of applications being made by the claimants for specific disclosure. There was actually an application for cross-examination, which was abandoned at the hearing. There was a whole history prior to the hearing, which the court was very familiar with and had very clearly in mind in my submission.
Thank you. Thank you very much. Mr. Beale.
If I may just come back briefly.
Yes, of course.
I didn't discern from that, I'm afraid, a knockout blow to the points of principle that I'll advance, but on a quick question of detail. Firstly, we've always accepted that the administrators weren't amenable to judicial review. The crux of this case, to some extent on the facts, lies in the fact that the Secretary of State did not himself conduct the fair, open, transparent award of a subsidy. He delegated effectively to the administrators the task of conducting what was described as an M&A process, merger and acquisition process. And there is a tension that's palpable throughout this case. But the JEA is quite understandably thinking, well, this is a sale process. We need to get rid of this ailing industry, this ailing supplier as quickly as possible. And there's a merger and acquisition urgency to the process they're going through. And then the Secretary of State, almost as a sort of bolt-on exercise after the event in the course of the SCA and the AOA, the two documents my lady Justice Whipple has identified as being the key documents in this case, adopts the process that's been adopted and says, because of that process, there has been a fair, open and transparent subsidy procedure, which is a separate legal issue as to whether or not that has been conducted fairly. Our challenge was directed squarely at the Secretary of State's adoption of that process as covering the ground necessary to give justification to the subsidy decision that was taken. And if I could direct the court to the fact that Teneo, as the administrators, according to the Public Accounts Committee report, Bundle 3, page 52, supplemental bundle, page 52, has itself been paid £49.9 million for its role in supervising the extrication of bulk from energy administration. So these costs, these legal costs that are sort of approaching 7 or 8% of that figure, are on top of the fact that they've already been paid for doing the very job that was given to them by the Secretary of State through the JEA process. So it's not with respect right that somehow all of this litigation focused on the JEAs. They were a necessary factual part to it. They would have had to explain their position even if they weren't formally an interested party. So that's the first point. The second point is, yes, it's true that the claim was brought by 3 claimants and therefore the costs are split, but the costs that have been incurred by the interested parties dwarf the costs that have been incurred by the Secretary of State. So dividing a large sum 3 ways doesn't stop it being a large sum. The final point is that Octopus is, of course, the beneficiary and the JEAs aren't. But if the Secretary of State had simply been the sole defendant and had called upon the JEAs to provide the evidence necessary to back up his assessment, they would have had to do the very job that they ended up doing. They just wouldn't have done so through the prism of a legal costs regime. They would have been paid for it as part of the energy administration, but they wouldn't have been entitled to the very substantial £2.7 million worth of costs that they have nonetheless paid. My lord, my lady, those are the only points in reply.
I think the efficient thing to do is, you know, effectively our decision on grounds 1 to 3. We don't know it on ground 4. I think we should simply think about the consequences and hear submissions on them now, and then we will give you our decision on ground 4 and on the consequential matters after we've asked you to rise again and had a discussion. So the points that we need to address are, I'm so sorry, I didn't ask whether my lord and my lady had anything they wanted to ask. No, on ground 4. No, the points we really need to address are estimates. Let's assume for the moment that the ground 4 is in, simply because it frankly won't make much difference, but to timing. Estimate any special directions over and above the usual directions. And I don't know whether Mr. Halliday wants to say anything more about his point that he flagged. Not quite sure how that will play out, but if there is going to be an issue about it, it's better we know about it now. So, estimate.
Sorry to interrupt. My Lord mentioned that if ground 4 is in, it's not going to add much time. Can I just make clear that our position would be that it would add considerable time, because as I've mentioned, the procedural history of all of this is quite complicated.
Yes, I see. It's a fair point. Thank you, Mr. Hickman. Well, let's assume it's in, and let's have estimates or views about this on the basis that it is in. I appreciate we don't have everybody here, but
I can make a starting bid.
Yes, that would be helpful.
3 days is what we think. We would reserve our position to argue that the appeal is academic for the reasons I highlighted. That could add a little bit of time, but hopefully the 3-day estimate would accommodate that.
And you would do that effectively by respondent's notice.
That's my anticipation, yes.
Yes. Well, I think we would want it. We need to know as soon as possible that was the position you were taking, and therefore we need a respondent's notice, and then it can be dealt with in Stonerson's in the usual way. Just thinking aloud here, would the respondent's notice require permission on that point?
I think not, because it's not a ground of appeal in itself. It's an additional reason for upholding the order below.
I think that's probably right. Anyway, if anyone says different, they can take the point when they see it argued. So 3 days on the basis of all 4 grounds and a possible respondent's notice.
Feels about right to us, I think.
And possibly a day's pre-reading ahead of that, which you may have been.
Well, we'll sort all that out for ourselves. Yeah.
I would say it would be more than that if we're having an argument about costs for the reasons I've given. I mean, we were 3 days below, and I think we had long days, and effectively we're going to go through everything again. Plus,
well, I'm not sure we're going to go through everything again, because there is not all the aspects of the decision are challenged, although I appreciate a great deal of it is.
well,
Okay. Thank you. There's no longer any, well, there's no reason for any special expedition. It's effectively all now about a declaration and a recovery. I've already expressed the view, I just put it out there in case anyone disagrees, that the question of relief, apart perhaps from a declaration, would have to be considered at a separate hearing, but I don't think it's appropriate now to decide where that separate hearing would be. Everyone seems to agree about that. I can't think of any other points about procedure. The usual timetables will apply. Does my lord or my lady want to suggest anything I may have overlooked? Parties?
My lord, just the question of the costs of today, as between appellants and the defendant and the respondent, if the court is minded to allow permission to appeal, then we would invite the usual order that the costs of today be in the appeal. We do invite you to make no order for the costs of attendance of the JEAs on the basis that my Lady Justice Whipple, I won't say expressly disinvited them, but suddenly did not extend the party invitation. And whilst they've crashed, they've therefore done so at their own expense, if I may use a colloquialism.
Mr. Hickman?
well, my lord, I mean, I see the faults in that, but at the same time, I think, given the points that have been raised, and given one of the grounds of appeal is expressly directed to my client, and I was invited to make submissions, that in principle it'd be right to make the same order.
We'll think about it.
My client.
Thank you. Anything else that we're going to kick ourselves for having to send you out again?
I think you do formally need to give permission for the extended supplementary bundle.
I'm obsessed about this.
I'm not.
I thought I had earlier. I thought I had. Oh, I see. Yes. No. Well, no, but I don't. You will have a better feel for this than I will. It's not to be assumed, is it, that the bundles will be in exactly the same form?
I would certainly hope not. I mean, the bundles we got for today seem manifestly inappropriate for the substantive hearing. I'd hope the parties can be sensible about that and come to some agreement.
I think what we'll need to do is, can I ask you to start thinking about bundles straight away? I can't remember what the timetable says. Some things are left rather late, in my view. Don't leave it to the last minute. Start thinking about bundles. Reach agreement if you can, if that requires an application for a bundle of more than 350 pages, which it may well. You'll have to make it at that stage, and you'll know what kind of bundle you're talking about and why.
Yeah. We will need, of course, to see the respondent's notice in any event before we can really finalise
Quite.
the bundle.
Quite. Very well. Well, I think everyone can leave again.